So Sherrilyn, I want to start by just flagging, I've sort of hinted at this, that one piece of feedback we have had on this series is that we were a little too flip. And we gave up on originalism too quickly since it seemed to have no rules or fixed methodology, and it seems to change weekly to reach the desired conclusion. But I would love for you to tell us how you define originalism and how you define this project of taking seriously the intentions and the actual language of the radical abolitionists who gave us the Reconstruction amendments.
Thank you so much. I do take it seriously. I don't think that originalism ever is legitimate as the sole means of interpreting a provision of the Constitution or even of a statute. It doesn't only matter what the original people who wrote the statute or provision thought. That's just, to me, that's a bankrupt form of judicial interpretation. And, you know, one thing I'm beginning to believe about this court is that it's a deeply anti-intellectual court. And I think the clue was given to us by Chief Justice Roberts, who you'll remember when he was confirmed, you know, it was a love fest. Everyone thought he was the smartest guy in the room. Well, not civil rights organizations, but, you know, that there was kind of this bipartisan sense that he was brilliant, right? That he was this amazing thinker. And I would say, you know, in that parents involved case, which is, was kind of the death knell of school integration when he, you know, struck down the voluntary efforts of school districts in Louisville and Seattle to engage in integration and offered us, you know, the idea of how we address racism in this country as a math problem, right? The only way, he said, to end discrimination based on race is to stop discriminating based on race. That's dumb. That's not smart. That is taking something that is incredibly complex, that is deeply embedded in the very formation of our country, that people spend years and years studying and trying to understand, and reducing it to a bromide. And I think that this is what originalism serves for this court as well. It's a nice, neat way of suggesting how you go about what should be the very, very complicated task of judicial decision-making. And I always thought judges were at the top of the pyramid in our profession, which meant they had the experience, they had the wisdom, they had the know-how, they had the supple intelligence to be able to do this, what I believe is an incredibly difficult, hard job with this tremendous responsibility. That's what I assumed they were supposed to be. And therefore, they shouldn't be looking for a way out that just says, well, let me just look up in a book and see what the person who wrote it thought. I never thought that. I do think, however, that whatever were the intentions of those who wrote the provision are important. It's important to know. I think it's a factor that I would want to have included in my decision-making and trying to understand how to interpret it at a particular moment. I don't think it's trying to get a snapshot of like who we were and then trying to recreate that. That is essentially, to believe that, is essentially to suggest that judicial decision-making is against progress. In other words, it doesn't matter what progress you create in the political realm, in the social realm, in the cultural realm, I'm gonna keep taking you back to this moment in 17 whatever, right, or in 18 whatever, and give that moment greater legitimacy than everything that has happened to now. And that's crazy. It's anti-democratic. It's preposterous. But I do think it matters. And so it really begins with whether or not the court is on the up and up. And this is where we have the problem. Because if you believe originalism matters, then you do think that the second Constitution, that is the Constitution created after the Civil War, is as important as the first Constitution. And you think that the people who created the 13th, 14th, and 15th amendments, which completely transformed this country, are also founders and framers, and that their views and intentions are also legitimate. And that's not what I see with this court. I don't believe it's an honest exercise, even of originalism.
Right, so I think we absolutely take your complaint that this Supreme Court relegates certain parts of the Constitution, especially the more progressive parts, to the trash can, and elevates parts that, in its view, deliver more conservative policy results. So I guess then the next question is can you foresee a world in which the entire Constitution, including the Reconstruction amendments, could be deemed equally compelling and equally important? And if so, where would that get us?
No, I couldn't, because I think so much of the second Constitution repudiates the first Constitution. Some of it is like very particular, right? It's like overturning the 3/5 clause by Section 2 of the 14th Amendment, right? There are actual things that happen that actually mean to repudiate the first part of the Constitution. And I think that that's important. The repudiation is a democratic move, right? Sometimes the repudiation is by provision, sometimes it's by social norms and cultural practices, that we repudiate things that happened in the past. And so even if those words are still on the page, I would still have to factor in the multiple ways in which our society has chosen to repudiate that language. So I don't think I'm looking for parity in terms of legitimacy. I don't think that the 3/5 clause has as much legitimacy as the 14th Amendment. I don't think, the parts of the Constitution about the migration and importation of persons. I don't think, I'll give you a 14th Amendment one. The 14th Amendment in Section 2 clearly is an articulation that the vote is assigned to men, right? Because it is the first time the word male is used in the Constitution. All right, that is obviously repudiated by a constitutional amendment that gives women the right to vote. But while I think there are other parts of the 14th Amendment, including of Section 2, that are important, that's been repudiated. This idea of voting associated with male has been repudiated. And so even in interpreting Section 2, I would read that out of it, right? Because it no longer can really exist. So I think it's the unwillingness to touch the text and the original intention, and to let it be commingled and to be sifted through the democratic actions that our society has taken in the meantime. And this is why I think I think that's hard, but that's why we pay you the big bucks, is that you're a judge because we're entrusting you with being able to do this complicated task. And unfortunately, that is not what Supreme Court justices, and I wouldn't just say Supreme Court justices, that's why we're putting 37-year-old trial court judges on the bench who've not tried cases. Because we no longer think that being a judge is a position of expertise and experience and wisdom. It is now just a patronage position, more or less. And so we'll never get away from originalism. Originalism will appeal tremendously to people who are patronage appointees, even if they're progressive. Because it's, just show me the book where I find what that founder said, and then I know what the answer is. But if we want to actually have judging be something that serves our society and that pulls together all of these strands, since it's going to make decisions for how we move forward, then I think, we have to see originalism as what it is, as just one piece of information that can help us figure out how we should imagine a particular provision existing in the now, but it is not the be-all and end-all. And of course, we can't say that I'm only going to look at the first Constitution. And I want to encourage you all to talk about it that way, by the way. I had a colleague say he's writing a book, and I said, what's it about? He said, the Constitution. I said, which one? And he said, and I said, exactly, because this presumption that we're all talking about that same document when invariably, particularly conservatives, are talking about the first Constitution. When they talk about the framers, they're talking about Madison and Jefferson and Hamilton, and they're not talking about Stevens, and they're not talking about Bingham, and they're not talking about Frederick Douglass, even the people who weren't actually legislators, but who influenced what those words mean. So I think we even have to not let them off the hook by presuming that when we say originalism, we're talking about that Constitution.
Sherrilyn, we're sitting here helping Sixth and I celebrate their anniversary. There's another big anniversary, which is Brown v. Board. A lot of folks missed it, but it's a big deal. And certainly in the podcast, we sort of touched on Brown v. Board, but I don't think we explored it nearly deeply enough. And in a sense, Brown both failed the originalism test on its own terms. Brown also supercharged what became originalism as we know it today. I think it's so interesting that Brown resistors spent a lot of years, first on, nullification and interposition, and then they landed joyfully, and I think they thought racially neutrally, on originalism, and specifically on original intent that was going to get them out from under it. I would love to hear you for a couple of minutes drill down both on Brown v. Board itself, but also the ways in which it became sort of the cause of and the cure for originalism, which has been unbroken in some sense ever since.
Yeah, Brown is playing, so the 70th anniversary of Brown versus Board of Education is on Friday, May 17th. And, it remains the most consequential Supreme Court decision of the 20th century. It has touched the lives of every single person in this room, whether they know it or not. And everything you did on your way here and what you saw on your way here and how you could be here and who you can be married to and who you can work for and what your rights are as a person in this country were shaped and affected by that decision. And it is the decision from which flows so much of the kind of modern progressive agenda and certainly statutory infrastructure. It also is the decision from which flows much of the conservative hysteria about rights and particularly about race. What I find most disturbing in this moment is how cynically Brown is being used. So just to go back to the originalist piece for a moment, the Supreme Court did ask the attorneys in Brown to, provide some research on the originalist history of the 14th Amendment. Did the framers of the 14th Amendment contemplate, when they were writing the Equal Protection Clause, that it would compel racial integration of schools? And if you've ever read the book Simple Justice, which is kind of the Bible of Brown versus Board of Education, there's a whole part about this intense research in which the NAACP Legal Defense Fund brought on board a whole set of eminent historians who were part of kind of the war room and did tremendous research and reviewed sections of the brief to make sure they were getting the history right. And they were as elevated by the history as they were deflated, because there were parts of the history that suggested that maybe it's possible that they thought that school integration would be included in this idea of equal protection, but there were more sections that suggested that it wasn't, right? That they were not thinking about integrated education, and for a whole variety of reasons. Public education is largely a product of the post-Civil War period. So public education was not among the rights that people thought about or considered during that period. And so again, our public education system, brought to you by the struggle for the freedom of Black people, is largely a post-Civil War Reconstruction phenomenon. So I don't have any problem believing that the framers of the 14th Amendment were not thinking about integrated public education. And of course, education was segregated in Washington, D.C. during that period, and so it seems hard to imagine that that's what they were thinking. But the Supreme Court was interested in that question too. But when the court issued its decision on May 17th, what the court said was, we've looked at the history and we found it inconclusive. In any case, this is how the court handled originalism. In any case, whether they were thinking about it or whether they were not thinking about it, there can be no question that today, education where it is offered must be offered on an equal basis. It is the very foundation, said the Supreme Court, education, of good citizenship. Education, said the Supreme Court in Brown, is the most important function of state and local governments. I mean, you don't hear that enough. We talk about the integration part, we don't talk about the education part. They said it is hard to imagine any child being successful without access to good education, and where it is offered, it must be offered on an equal basis. So the Supreme Court in Brown heard the originalism argument, read all the materials, and said, you know what? Whatever is the outcome of the originalist quest to find out what they thought, we got to deal with the now. And today, unlike in the period when the Equal Protection Clause was written, education is the very foundation of good citizenship and is the key to unlocking the ability of any child to succeed, and made the decision on that basis. And I think that's become kind of the piece they're pulling. When they say, do you think Brown was correctly decided? I've come to believe they're more talking about that than anything else, right? I used to think they were just being racist. But
They
now-
were.
Which
And
is
I'm not
always
saying-
a
I mean,
decent bet. But
two things can be true. I actually do think that part of it is that. It's like it's also, they're like holding that to kind of put in the, because they don't really have the guts to kind of go front bore for Brown right now, but they're kind of holding that piece, like that it wasn't correctly decided because it wasn't decided on originalist terms. And I think now the court has decided that Brown is so useful to the conservative takeover plan that they actually don't want to get rid of Brown anyway, because Brown can be hollowed out, but the husk remains and can be used for all kinds of purposes, like pretending that the Dobbs decision is the same as Brown, and using Brown for the proposition that you see stare decisis, that is precedent, doesn't always have to be respected. We can overturn decisions just like Brown overturned Plessy versus Ferguson. So I think Brown has been having this usefulness for them, while they're, of course, hollowing it out with all of these decisions, right? So that the very meaning of Brown has kind of lost its power. But it is useful to be able to point to it, because who would argue against Brown? And if I can point to Brown and say, see, Dobbs is just like Brown, that's supposed to give Dobbs some shine and some imprimatur of legitimacy. I mean, it's grotesque. It is incredibly cynical. But I've decided that's the project now. That, like, well, actually, let's let Brown stick around for a minute so that we can use it for these purposes.
So Justice Ketanji Brown Jackson has spoken of originalism in positive terms, and always through the lens of the Reconstruction amendments, using the methodology that you support. And she's been on the court now for a couple of terms. I think she's been pressing her conservative colleagues to look at the actual history and look at the 14th Amendment. Can't say it's been super successful so far, to put it very mildly. And so I'm curious what you think of her performance so far on the bench in this regard, and specifically her attempts to sort of shame the majority out of its bogus and ahistorical originalism.
Which is an incredibly worthy project. I think she's been fantastic. And the reason I think so is because, you know, Supreme Court decision-making arguments, the announcement of decisions, the alchemy of it is, it's not linear. It's not just about what the outcome of the case is. You know, I think the work of Ketanji Brown Jackson to compel this encounter with the true history of the 14th Amendment, and to take originalism on their terms and to try to best them at their own game, is one of the reasons we're having this panel today, right? I think it's been powerful because she is exposing that this is bogus, right? She may not mean to. She may be really serious that she thinks it's great too. I don't think so. I think she thinks it's one factor as well. But she's at least saying, well, if you want to do it, and I respect this because I'm a litigator, and I've told you this before, Dahlia. Tell me what the rules are, and I will do the rules. And I like my chances. I'm not gonna, you know, I'm gonna go into court and I'm exactly what you told me to do, and I'm gonna do it better, right? And maybe there's a little bit of black girl stuff in there too that we were just told we had to be better. So I just want you to tell me what the rules are, and I think that's what Ketanji Brown Jackson is doing. She's saying, oh, the rules are originalism. Let's, right? And I appreciate that. And so what she has done is expose that the rules are apparently not originalism, as we can see from the Trump versus Anderson case, the Section 3 case about removing Trump from the ballot. It's not that they want to have a genuine and honest encounter with originalist intention. No one could read the original materials around the 14th Amendment, particularly around Section 3, and be confused about what the framers of Section 3 were trying to do, what they feared, what they knew lived in the spirit of this country, not just at that time, but what they feared going forward would continue to be this disastrous spirit of insurrection, and the way they wanted to undercut it. So what she basically is doing is showing that the game is rigged. And that is always helpful to have folks inside. I know we're saying it outside, right? But it's also really helpful because you know that these are people who believe in the institution, who actually are not trying to throw flames. These are not people who want to burn it down. These are people who want to believe in it, who are prepared to make compromise and to do the kind of horse trading we remember from years past. And when they tell you, as the 3 women justices have been telling us, that the majority is in the tank, right, for Trump, or that the originalist posture, right, is empty, then I think that's incredibly powerful, and it helps soften us up for what inevitably I believe has to be a kind of restructuring of the Supreme Court, how it functions, obviously ethical code, all of that stuff, but that's what has to happen. It can't be about just slotting some new people that we like better into the seats. It can't be. And so I appreciate what she's doing because I think it is creating an environment in which the game is so powerfully exposed that it is only a matter of time before people are fully ready for the kind of transformation that the court will need.
Sherrilyn just said 2 things that are going to, I think, segue really beautifully to our next panel. One is that the cri de coeur that you have given us on Amicus over the years is this question of, is this how we do law now? And we're about to hear, is this how we do law now? And the really important thing embedded in what Sherrilyn just said, which I think you have always said to us, this is not an abstraction. This is not a show about originalism. It is not a show about the dead hand of the Supreme Court and how we have to just live with this. What you just said, I think, is such an important theme of tonight's show, which is it is a choice. It is a choice to think that we have no choice on this issue. And truly, truly, nobody has ever modeled for me more than you have that we all have skin in this game. We have to choose to put it in the game, and we don't have the luxury to wait around till 20 years from now to buy in. So Sherrilyn Ifill is a civil rights litigator and scholar. She served as president and director counsel of the NAACP Legal Defense and Educational Fund until 2022. She is the inaugural Vernon L. Jordan Chair in Civil Rights at Howard Law School, where she is founding director of the 14th Amendment Center for Law and Democracy. Friends here at 6NI, friends who are listening at home, wherever Sherrilyn tells you to go, I think you should go. Sherrilyn, thank you so much.